In these coordination meetings that you had for the implementation of the order, you, to the best of your knowledge, or as far as you can recall, do you know whether these departments, institutions were invited to these meetings?
I think I had earlier stated that I know that there were a lot of people. I mean, in the implementation coordination meeting. I mean, but then to recall exactly who was present from which department, apart from, like I said, I mean, the police officer, I mean, who was conspicuous through the uniform that he was wearing. I mean, it was an operational uniform. I mean, I would not be able to really, I mean, recall exactly who was present. But they should have been invited to the meeting. But there were quite a number of people.
Okay. Take a look at emoji 5C, that is the second High Court order.
Mm-hmm. Emoji 5C.
Yes, that is the order dated Monday, the 21st day of July 2017.
Okay, it says emoji 2 in my file name.
Oh,
Yeah.
okay, sorry.
Uh,
The naming of the document, there must have been an error with it. But if you do look at the top of the first page,
mhm.
it's labeled emoji 5C.
Yeah, it says emoji 2 and then emoji 5C.
Yes,
Mm-hmm.
that's it. Um, if you look at the order, there are a few companies that were also identified again.
Mm-hmm.
Um, there were also bank accounts and properties listed
Mm-hmm.
at the back of the order.
Yeah.
Yes. So this order, by the time it was being sought for and obtained from the court, the commission was already established.
Mm-hmm.
Yes. So what was the rationale for the second order? Um, couldn't the work just be handed over to the commission for their investigations and further work?
Well, I mean, like I said, I mean, the purpose of the uh, orders was to preserve, I mean, to prevent dissipation of the assets. And of course, I'm not sure how far, I mean, at the time the commission had already started, operations. I know that it was already established. I mean, so my hunch would be, I mean, that the fastest way was to have basically obtained this order from the High Court, since the High Court had already granted an initial order. I mean, and then basically the commission can deal with the assets which have been the subject of the freezing. So, in terms of the timeline, I am not sure whether the commission at the time had already, I mean, started dealing, I mean, with the matters under its purview or not. But if the order was obtained whilst the commission was on, I believe the intention was to preserve the assets so that the commission basically would have, I mean, something to deal with. Because if the assets are dissipated, clearly, I mean, the commission would not have any mandate or jurisdiction over assets which does not exist.
Very well. So we would now move to the issues regarding the establishment of the Commission of Inquiry.
Mm-hmm.
We can see that the President issued a Commission of Inquiry through a legal notice number 15 of 2017.
Yes.
Have and there are various annexures or attachments to the legal notice.
Yes.
Yes, a list of landed properties, a list of companies, and a list of bank accounts with the commercial banks
Mm-hmm.
of the former president and his companies.
Mm-hmm.
All right, so In the day we are in now, we can see that there's been a commission of inquiry. I think this government can say that there are no beginners when it comes to establishing commissions of inquiry.
Mm-hmm.
And we've seen that in the TJ process, the transitional justice process for the Gambia, we started with the Jammeh Commission, then we had the TRRC, and we had the CRC for the constitution drafting as well.
Mm-hmm.
But why was this? Do you know? Can you tell this committee why this style was used, as opposed to the others that were subsequently established by the government? The legal notice and everything that it just entails, the drafting of it. I mean, I'm referring now to the not to the content, but to the establishing document.
Why? Which style would it be? A commission of inquiry style?
Yes, the this one as opposed to what the TRC had, which was an act of the National Assembly.
Okay. No, I mean, I think they have different sources. I mean, uh, commissions of inquiries are established, as you may well know, under the Constitution. I mean, Section 200. And so, I mean, once a commission is being established under Section 200, this is the usual style. I mean, to do so through a legal notice. I mean, because there's already, I mean, adequate constitutional provision. I mean, for a commission of inquiry to be established by the president. When it comes to the other commissions, I mean, these are not commissions that are grounded in the Constitution in terms of specific provisions of the Constitution. If there was, I'm sure it would have been easier to also go through a legal notice. But these were, I mean, commissions that basically were part of a transitional justice process. I mean, and of course, a transitional, process of, a democratic process. So that's why they had to, be established through, a legal, instrument, act of parliament, and of course, with detailed provisions about the functions, the membership, and everything else. That standalone commission, would have. So that's the difference between the two.
All right. Now that we're talking about establishment, after the, or let's say before the legal notice was published,
Mm-hmm.
the personnel or the top critical personnel for the commission had already been engaged in conversations and appointed. That is why their names are reflected for the commissioners. The names are reflected on their legal notice.
Correct.
But we can see that they also received their appointment letters on the same day as as the legal notice was
Mm-hmm.
published.
Yes.
And then subsequently, of course, as the commission would need support staff, would need a secretary, the appointment was done, and of course, support staff that would aid the commission and the commissioners in the execution of their duties.
Mm-hmm.
We can see from the records that these, apart from the secretary who was appointed from the private sector,
Mm-hmm.
most of the, or we can say all of the support staff of
Mm-hmm.
the Commission of Inquiry were from the government departments. Some from
Mm-hmm.
the OJ, others from the judiciary, and
Mm-hmm.
we have the security forces that
Mm-hmm.
helped in investigations and providing security for the commissioners.
Mm-hmm.
For the support staff of the commission,
Mm-hmm.
assistants, secretaries, accountants, those sort of that class of personnel.
Mm-hmm.
What was the rationale for obtaining them from the public service, from the civil service?
Thank you. Well, if you look at, the history of commissions of inquiry in the Gambia, which I also had the privilege of serving as counsel in one of them, the Gamtel, Fiber Optic Commission. From 94 onwards, at least, since when I started following commissions, it's always been the case that commissions are staffed, by public servants, from the secretary, sometimes to even the commissioners, and of course, support staff. So in this particular situation, I think from the very beginning, there was a lot of emphasis as a policy, I mean, uh, decision to make the commission, at least the core commission members, and the secretary and the council, as independent of, the public service as possible. Of course, you would understand that this was immediately after the change of government, perceptions about fairness, perceptions about witch hunting, could be very high. And so it was important, for the government to make sure, that people who were inquiring into, financial, irregularities, so to speak, of the former government, of the former president especially, and of course his close associates, were seen to be people, who were not very much really close or linked, to government through public service. And so I think for the first time, you had a situation where, the commissioners and the secretary and the council, were not from the public service. But of course, the commission being, an ad hoc commission, which was supposed to last for a very short period of time, meant that it could not really wholly, consist of people from the private sector or from outside of government. So there has to be a hybrid sort of, whereby at least when it comes to support staff, for the commission, people in the public service, would be, engaged, to help, with the work of the commission. And of course, in terms of the legal support, we also saw it as an opportunity to build the capacity of the local staff, at the state council, at the ministry, to learn under the, guidance and experience of the lead council. So of course, some, when, in fact, it was on request from the, from the lead council that she needed support. Some state council were assigned to be able to really, not just support, but also to learn, on the job, so that in future they could also be able to be in a position to do so. So it was a hybrid mechanism, to make sure that the commissions, was able to function properly. Not just consist of people who were wholly outside of the public service. That's why certain public servants were asked to support.
In requesting for or having, it does make sense that considering from the legal notice, it was envisaged that the commission would last for 3 months, which is quite ambitious, considering the volume of work that it had to do. But in taking staff or personnel for the commission within the service, did that not require that these people would take a break from the initial duties or from the duty stations and then move to the commission to support it in executing its duties?
Actually, what was envisaged, when, this support was being, organized, was that, they would go in and out as required by the exigencies of the commission's services. So at the beginning, you would find that, for instance, for the lawyers, they would basically go in, and support, but when they have cases in court, they will go to court and do their cases after they finish, I mean, their cases, they would basically join the commission. I mean, so the support that was envisaged was not a full-time sort of, I mean, support. It was basically to juggle between the two, like previous commissions. I mean, have done before. I mean, so it wasn't really envisaged that they would move entirely. I mean, to the commission, which would have warranted that they would be seconded. I mean, of course, with time, with the evolution of the commission's work, I mean, I think most of them found themselves more and more, I mean, engaged, I mean, full time for some of them, with the commission. I mean, and only come to the ministry, I mean, when they are needed for specific tasks. But like I mean, to put it, I mean, in brief, I mean, the idea was to basically, I mean, run between the two institutions and provide the necessary support as and when needed. That's why it was done that way.
But how come the records don't show that these personnel would be expected to maintain their primary duties but also support the commission and its duties as well? Because from the records that we have seen for requests of personnel from other departments, like the judiciary, for example, it doesn't state that they are expected to work part time with the commission, but rather that they should report to the commission.
Hmm. Yeah, I mean, it may not have been written on paper, but like I said, this was the understanding. I mean, the understanding was that if you are basically assigned to help with the commission, I mean, you do so. I mean, whilst juggling, I mean, with whatever other responsibilities you had. I mean, this was the envisaged strategy in order not to, I mean, lose, I mean, from, I mean, their work and to basically able to also support, I mean, the cause of the commission's work.
But so, do you know whether this ever caused an issue for the commission or for these personnel's primary duty stations? Whether there was ever an instance
Yes, indeed, like
where
sorry.
where there were whether there was ever an instance where they had issues of where to report to or where not to report.
Actually, the only time that, I mean, an issue arose, I recall, I mean, was when the lead counsel actually, I mean, felt that she wasn't getting enough from, I mean, the counsel that were assigned to her. I mean, I think because sometimes she would need their attention and she would be told that they're prosecuting a case somewhere and that they will be back. And so I think out of, I mean, the need to, have them, I mean, at the commission more full time, I mean, she actually wrote a letter, I believe, basically, I mean, requesting that, I mean, she needed, I mean, this council or state council to really, I mean, be at the commission more than what they were doing at the time. So, but apart from the council, which was done subsequently, I think, I mean, all the council who were assigned were basically asked to, I mean, work with other state council to make sure that their cases were being prosecuted until the commission, I mean, was able to finish its work. Apart from that, I think I don't recall any other issues. I mean, with regards to staff who were, I mean, juggling.
We do have here a letter from the commission addressed to you
Mm-hmm.
asking for confirmation of a few staff,
Mm-hmm.
namely Alhaji Babu, Sana Gassama, and Andy Seka,
Mm-hmm.
whether they are members of staff of the Commission of Inquiry. And
Yes.
from,
Mm-hmm.
yes, and from this, also a response from you to the Commission as well,
Mm-hmm.
confirming that they are part of the Commission but also have to maintain their duties.
Mm-hmm.
And when the first secretary of the Commission of Inquiry testified, he did state that procurement, accounts personnel were not stationed at the commission at all, and have to make requests, or sometimes he has to go, of course, write letters and stuff, make requests to MOJ to have these things facilitated. Which now, if we look at it, you can see that these things did cause delays and some issues for the commission.
Mm-hmm. Yes. Thank you. In fact, I must have, forgotten about that. Yes, indeed. Alhaji Babu Juf was the accountant of the Ministry of Justice, who was basically also, helping out with the financial transactions of the commission. And the Seka was the procurement officer of the ministry, and Sana was the coordinator, or chief driver, they called him. So, ideally, the Commission of Inquiry should have been a self-sustaining body, maybe, or a self-accounting body, whereby it would have its own accounts, whereby it would report directly, to, the accountant general and all that. But that wasn't the case. Like all commissions, it was an ad hoc arrangement whereby the commission was not a self-accounting body. And so that meant that Alhaji Babu, the accountant, had to basically, run between the two institutions. Of course, Andy also, the procurement officer, if the commission needed anything, it needed to be procured, and procurement was directly linked to accounts because the money that was basically to be used for procurement of goods and services was come from the accounts. And of course, the chief driver, Sana, also had to coordinate, the drivers at the commission, whilst at the same time keeping an eye on the drivers at the ministry, because, as you would may or may not know, the commission didn't even have enough vehicles. So there was a lot of, vehicles that were plying between the commission and the ministry. For instance, when some lawyers needed to go to court and there weren't enough vehicles, the chief driver would make sure, the vehicles were available from the commission to do those runs. So clearly, I think the commission, felt that, the part-time arrangement, wasn't very convenient for them. But of course, it was out of necessity because these were, based on the constraints of the setup of the commission, which needed these people to both serve the commission and the ministry. But eventually, I think they understood, and all the payments and the procurements, and of course the vehicle arrangements, were sorted out.
Okay. But now, in hindsight, or at least now that it's been a few years and we've seen what has happened with staff reporting between two institutions, and the delays it has caused, the issues that would arise that would cause small problems here and there for both institutions, for both the commission but also for the ministry or even those that came from other departments. From records, it shows that even the transcribers from the judiciary also need to sometimes run back to the judiciary. Now, in hindsight, do you think this model that was adopted back in 2017 is something that is ideal for a commission of inquiry?
Actually, I think it's more of a resource than the model. The model, I don't see any problem with it because it's, based on the realities of the time. But if you're talking about the ideal, ideally, certainly, a commission of inquiry should have all the resources that it needs to be able to, do everything that it requires without, the support of the Ministry of Justice. If that happens, I think that would best serve the purpose of the commission. The reality is that, first of all, commissions are not self-run, and that's, a problem that has to do with accountability department on their IFMIS system. And of course, our resources are not always, allocated on time. And so, that would mean that, the commission does not have an alternative to draw on. Sometimes the work of the commission can actually come to a standstill. And so, I mean, uh, when it comes to, personnel as well, sometimes even the, allowances or emoluments that are given, to, staff who are helping out, are delayed. And, all these are problems that would really cause a commission to come to a standstill if it were really, if it were not to have the required support system, that current system has. So I think it's more of resourcing. Ideally, a commission should be resourced to the extent that it would not have to rely on, support from anywhere else. And if I am to basically have the opportunity of doing so, I think that's what I would do. Yes.
Okay, so for you, you think the resource allocation is what's causing the most issues, or what caused the most issues for the commission rather than the personnel that are moving from one
Yeah.
department to another?
Yeah. Indeed.
Okay.
If resources are made available, then I think the commission will be able to.
Mr. Marenah, can you repeat what you said?
No, yeah, I said it's a resourcing issue. I think if the commission recovery is well resourced, then it would be able to take care of all its needs without the need for any support system around it, as it currently happens.
And in well resourcing, that would mean to allow for the commission to a commission of inquiry to manage its own funds through the accountant general, rather than passing through the
Yeah,
ministry
to
of.
be a self-accounting.
Yes.
Yeah, to be a self-accounting entity, and of course, not just self-accounting. In name, but to also give as much money as they need, as when they need it, basically.
All right, that's fine. Still on staffing issues, we will now talk about the secretary. But
Mm-hmm.
the second secretary, or should we say the assistant secretary,
Mm-hmm.
because eventually in 2018, the secretary of the commission was relieved of his duties in June, or in July rather, and then the Deputy Permanent Secretary of the Ministry of Justice, Mr. Ramatulai Saad, was asked to report to the Commission of Inquiry as the new secretary, slash assistant secretary, whichever one, but it's not clear. And from her testimony, she has informed this committee that she had requested an appointment letter, or a letter that would instructing her to report to the commission. However, that is not something that she was able to get, and what she received was what the commission received as well. She was given a copy of a letter addressed to the chair of the commission, informing the chair that Mr. Ramatulai Saad will be reporting to the commission as the secretary for the commission. Were you, did Mr. Ramatulai Saad ever speak to you about an appointment letter, or did you realize after her moving from the Ministry of Justice to the Commission that she was not indeed giving a letter, even for the role of Assistant Secretary?
First of all, I definitely do not recall. any request for a letter, for an appointment letter. And secondly, if that request was done, I believe it would have been very easy to really get an appointment letter, because I believe that when the secretary was relieved, the attorney general did get the blessing of the executive. To appoint Mr. Ramatullah Sir, to take over the duties of the secretary until the conclusion of the commission's work. And so I do not. The answer is that I do not recall receiving any request for an appointment letter. No. But it should have, an appointment letter should have been, should have been issued, and I am surprised that it actually was not issued, and I believe it would have been very easy, to issue one, if indeed, the request was done.
Okay, for her, she made the request to the AG and not to the Office of the Solicitor General, so maybe perhaps that is why she did not get an appointment letter, but still, such a critical part of the commission as the Office of the Secretary. I do believe that that should be well documented, and the person relieving or taking over from the first secretary should have also been given proper documentation to assume that office.
I agree with you totally. I think it must have been a serious oversight. If that was not done. But like I said, I'm sure. Writing an appointment letter. After having gotten the blessing of the executive would have been very easy. But sometimes some of these things happen. But it should have been done. I agree with you entirely.